The air in courtroom 3B hung thick with anticipation, a suffocating silence preceding the inevitable pronouncement. Every breath seemed held captive, every eye fixated on the pale, stoic face of Judge Harding as she received the sealed envelopes from the foreperson. At the defense table, Elias Thorne, once the titan of tech, now a man whose empire lay in ruins, shifted restlessly. His perfectly tailored suit couldn't conceal the tremor in his hands, a visible crack in the facade of his usual self-assured composure. Across the aisle, Clara Vance, the whistleblower whose courage had ripped open the corporate veil, sat rigid, her gaze unwavering, a silent prayer etched onto her features. Beside her, David Harrison, an investor who had lost more than just money, gripped the armrest of his chair, knuckles white. The clerk's voice, clear yet tinged with a solemnity that bordered on the funereal, began to read. In the matter of the charges against Elias Thorne, on the charge of securities fraud against Clara Vance, we the jury find the defendant, Elias Thorne, guilty. A collective gasp rippled through the gallery. For a fleeting moment, Elias Thorne's carefully constructed composure shattered. His eyes, usually sharp and calculating, widened, a raw, primal shock registering before he quickly reined it in. Clara Vance, however, felt a wave of profound relief wash over her, so potent it threatened to buckle her knees. Tears, hot and stinging, welled in her eyes, blurring the faces around her. It wasn't triumph she felt, but a deep, overwhelming sense of vindication for the relentless fight she had waged, often against insurmountable odds, to expose the truth. For years, she had carried the burden of Thorne's deceit, the weight of his lies pressing down on her integrity. Now, a portion of that immense burden had been lifted. The clerk continued, pulling the courtroom back into its tense reality. On the charge of securities fraud against David Harrison, we the jury find the defendant, Elias Thorne, not guilty. This time, a different kind of murmur swept through the room. David Harrison, who had braced himself for a verdict that might restore some of his lost fortune, felt a peculiar mix of disappointment and pragmatism. While not the full justice he had hoped for, the partial accountability, the fact that Thorne was still found guilty on a major count, felt like a small victory. He looked at Elias Thorne, who, despite the partial acquittal, still looked like a man condemned. "At least he's not walking out of here," David murmured to his attorney, a quiet acknowledgement of the ongoing detention and the gravity of the charges that still clung to Thorne. The weight of his own financial losses still smarted, a dull ache that wouldn't entirely fade, but the image of Thorne's fleeting moment of despair offered a grim satisfaction. And on the charge concerning former CFO Lena Chen, we the jury are unable to reach a unanimous verdict. The final declaration hung in the air, a testament to the persistent fissures within the jury. Elias Thorne, even with the partial not guilty, remained shackled by the guilty verdict for Clara Vance and the lingering uncertainty of Lena Chen's charges. The courtroom pulsed with unresolved tension, a clear sign that this legal drama was far from over. The initial shock began to give way to a strategic hum as legal teams began to assess the implications of a split decision, knowing full well that partial justice can often be more complex and more contentious than a clear-cut win or loss. The revelation of the partial verdict was merely the prelude to a far more disturbing drama unfolding behind the closed doors of the jury room. What the public didn't see, what the media couldn't capture, was the escalating inferno of animosity that had consumed the 12 ordinary citizens tasked with finding justice. For days, the jury's deliberations had been a microcosm of human conflict, a crucible of clashing personalities, deeply held beliefs, and wildly divergent interpretations of the mountain of evidence presented. The initial intellectual disagreements had curdled into personal slights, then open hostility, culminating in a dramatic, almost unthinkable breakdown. Foreperson Daniel Hayes, a retired school principal known for his calm and reasoned approach, had tried tirelessly to mediate. He had appealed to their civic duty, reminded them of their oath, urged them to set aside personal feelings in pursuit of a collective truth. But the tension in the room was a living, breathing entity, a toxic cloud that thickened with each passing hour. Disagreements over a particular spreadsheet, a witness's credibility, or the nuanced definition of intent to defraud would quickly spiral into accusations, raised voices, and thinly veiled contempt. The air itself crackled with unspoken threats, a volatile mixture of frustration and exhaustion. It was during a particularly heated exchange, a desperate push to reach a consensus on the Lena Chen charge, that the dam finally broke. A juror, whose identity would remain protected for reasons of safety and court integrity, had erupted in a fit of rage, his words cutting through the already strained atmosphere like a razor. "You want to keep pushing this? You just wait until we're out of here, Hayes. You'll regret crossing me. You have no idea what you're messing with." The words, though not a direct physical threat, carried an unmistakable menace, a chilling undercurrent that spoke of retribution beyond the confines of the courthouse. The room went silent, save for Daniel Hayes's ragged breathing. His heart hammered against his ribs, not from fear, but from a profound sense of violation. This wasn't a debate. It was an intimidation tactic, a crossing of a sacred line. Daniel Hayes, a man who had faced down unruly teenagers and demanding parents for decades, felt a cold dread creep through him. This was different. This was personal, and it felt genuinely dangerous. He couldn't shake the feeling that the threat wasn't just idle bluster. His resolve, which had guided him through grueling hours of deliberation, fractured. He rose, his voice strained but firm. "I cannot continue. I feel my safety and the integrity of this process has been compromised." The shock that permeated the courtroom when Judge Harding announced her decision was palpable. Given the escalating hostilities reported within the jury, including a credible threat to the foreperson, "I am compelled to send the jury home early today," she declared, her voice heavy with regret and a steely resolve. "Deliberations will resume tomorrow morning, under heightened security measures. We will ensure the safety of every juror and the sanctity of this process." The sight of bewildered jurors being escorted out by uniformed officers, some looking shaken, others defiant, painted a stark picture of a justice system teetering on the edge of chaos. The public gallery buzzed with speculation, whispers of what could have possibly transpired behind those soundproofed doors. The following morning, in the quiet, hushed sanctity of Judge Harding's chambers, the true extent of the jury's dysfunction was laid bare. Daniel Hayes, still visibly shaken but determined, recounted the incident from the previous day. His voice was low, laced with a mix of anger and a quiet plea for understanding. "Your Honor," he began, "during the debate about Lena Chen's involvement, juror number 7, Mr. Henderson, became incredibly agitated. When I tried to steer the conversation back to the evidence, he slammed his fist on the table and said, 'You keep pushing this, Hayes, and you'll regret it. There are consequences outside this room, and you're not ready for them.'" Daniel's gaze met Judge Harding's, a silent question hanging between them. "What do we do now?" Judge Harding listened, her brow furrowed in a deep frown. She recalled a note received weeks prior about a juror refusing to speak to another, or a complaint about a particular juror's overly aggressive questioning during discussions. She had dismissed them then as the usual stresses of a long trial, a cliquish behavior that often emerged when people were cooped up under pressure. Now, the playful term felt chillingly insufficient. "Childish squabbles," Judge Harding muttered, not to Daniel but to herself, a sigh escaping her lips. "This is beyond frustrating. We've got a defendant facing years, potentially decades in prison, and the foundation of his judgment is crumbling due to this. Her words, though harsh, underscored the immense pressure she was under. The sanctity of the judicial process, the very concept of a fair trial, was being undermined by interpersonal dynamics that felt more appropriate for a schoolyard than a courtroom. Daniel Hayes nodded grimly. It wasn't just Mr. Henderson, Your Honor. The entire atmosphere it's polarized. There are two distinct groups, and anyone trying to bridge the gap gets ostracized. One side believes Mr. Thorne is unequivocally guilty on all counts, a pure villain. The other sees him as a victim of opportunistic investors, a visionary unfairly targeted. And when we moved to discuss Ms. Chen's complicity, those lines solidified even further. Half the room saw her as Thorne's willing accomplice. The other half believed she was merely a compliant employee, fearing for her own job, swept up in a scheme she didn't fully grasp. The discussion illuminated the destructive dynamics that had taken root. The pressure cooker environment of deliberations, coupled with the weighty responsibility of their task, had exacerbated minor irritations into profound resentments. Cliques had formed, not just based on interpretation of evidence but on personality, background, and perhaps even subconscious biases. The courtroom wasn't just a place of legal argument, it was a psychological battleground, and the jurors, ordinary citizens thrust into an extraordinary role, were ill-equipped to navigate the treacherous emotional landscape. The judge, the legal teams, and most importantly, the defendant, were all at the mercy of this deeply dysfunctional, volatile group, their fate hanging in the balance of unspoken animosities and raw human fear. With the disturbing revelations from Daniel Hayes echoing in her mind, Judge Harding returned to the courtroom, her expression a careful mask of stern resolve. The atmosphere in the room was thick with anticipation and thinly veiled curiosity. Spectators leaned forward, reporters poised with pens, sensing the unprecedented drama that was about to unfold. When the jury re-entered, escorted by no fewer than 4 additional security personnel, the tension became almost unbearable. Each juror's face was a tableau of emotions. Some looked drawn and pale, others defiantly unyielding, while a few avoided eye contact altogether, as if ashamed of the internal conflict they carried. Daniel Hayes, though still weary, held his head high, a silent testament to his courage. Judge Harding's gaze swept across the jury box, her voice, when she spoke, cutting through the silence with an almost physical force. "Members of the jury," she began, her tone leaving no room for doubt or dissent. "I am fully aware of the difficulties you have encountered in your deliberations. I understand that the pressures of this trial and the gravity of your responsibility are immense. However, I must remind you of your oath. Your duty is to deliberate fairly and impartially, based solely on the evidence presented, and to reach a unanimous verdict where possible." She paused, letting her words sink in, emphasizing each syllable. "The partial verdicts you delivered yesterday have been formally accepted and recorded. This means the charges concerning Ms. Clara Vance have been resolved. The charges concerning Mr. David Harrison have also been resolved. Your current task, and your only remaining task, is to reach a unanimous verdict on the outstanding charge involving Ms. Lena Chen. This court will not tolerate any further disruption to the integrity of this process." To underscore the seriousness of her warning, Judge Harding then took an unusual step. "Given the events of yesterday, and to allow for a necessary period of cooling off, I am now going to give you a mandated break. You will return to the jury room in 1 hour, and your deliberations will continue under close supervision. I expect respectful and professional conduct from every one of you." The court broke for the recess, but the unspoken questions hung heavy in the air. How could a jury, so clearly fractured, possibly come to a unanimous decision? What would close supervision entail? Would security personnel be stationed inside the room? The prosecution and defense legal teams huddled, strategizing feverishly. For Nathan Coleman, Elias Thorne's lead defense attorney, the jury's internal strife was a double-edged sword. While it might lead to a hung jury on the remaining charge, a small victory, it also exposed the proceedings to accusations of unfairness, providing fodder for a potential appeal. For the prosecution, the continued division was frustrating, a stumbling block in their quest for full accountability. The fate of Lena Chen's complicity, and by extension, Elias Thorne's complete legal picture, now rested on a jury that seemed more prone to internecine warfare than reasoned debate, under the watchful, unblinking eye of the court. The scales of justice were not just weighing facts, they were now weighing the very nature of human interaction under pressure. The courtroom, still buzzing with the aftershocks of the jury's internal strife, fell silent as Elias Thorne's defense attorney, Nathan Coleman, rose to address the bench. His voice was firm, yet carried a theatrical weight. Your Honor, given the unprecedented and alarming breakdown in jury decorum, the documented threat against the foreperson, and the judge's own acknowledgement of widespread hostilities and childish squabbles within the panel, we must formally request a mistrial on all remaining counts. The proceedings at this point are fundamentally tainted. My client, Mr. Thorne, cannot possibly receive a fair trial under these chaotic and compromised conditions. Elias Thorne himself, his face a mask of carefully controlled desperation, then stood, seeking to add his voice to the plea. His eyes, usually cold and imperious, now held a glint of genuine fear. Your Honor, he began, his voice surprisingly steady despite the tremor in his hands. I have dedicated my life to innovation, to building something truly transformative. I have endured countless attacks and I have trusted in the legal system. But what has transpired in that jury room? It's a mockery of justice. How can any man be fairly judged by a group so consumed by internal conflict and, frankly, animosity? My liberty, my entire life, hangs in the balance. I beg you, Your Honor, do not allow this chaos to define my fate. Grant us a mistrial and let us restart this process with a jury truly committed to fairness. His words, delivered with a mix of practiced sincerity and raw vulnerability, momentarily stunned the courtroom. Thorne, the man portrayed as a ruthless schemer, was now pleading for mercy, a man reduced to begging for a chance at a fair shake. But Judge Harding, ever the bulwark against emotional appeals, remained unmoved. Her gaze, though acknowledging Thorne's distress, was unwavering. Mr. Coleman, Mr. Thorne, she stated, her voice devoid of sentiment, the court has addressed the jury's conduct. Security measures have been enhanced, and specific instructions regarding their duties have been reissued. While unfortunate, the jury's internal dynamics, unless they demonstrably prevent them from making an informed decision, do not automatically warrant a mistrial. Your request is denied. Deliberations on the remaining charge will continue as ordered. The prosecution then rose, seizing the moment to reiterate the gravity of the charges against Elias Thorne, painting a stark picture of his alleged crimes. Prosecutor Evelyn Reed, her voice sharp and uncompromising, laid out the core of their case once more. He enriched himself at the expense of others, jeopardizing their savings, their retirement, their very livelihoods. His actions were not aggressive business decisions. They were a meticulously orchestrated fraud, a criminal enterprise disguised as innovation. Nathan Coleman, Thorne's defense attorney, countered, his voice resonating with a practiced charm. Your Honor, the prosecution's narrative is a caricature. Mr. Thorne was a visionary, operating in a high-stakes, rapidly evolving tech market. What they call falsified earnings were aggressive accounting methods, common in startups seeking to attract vital capital. What they label deception was a bold strategy to present the company in its most favorable light to investors who fully understood the inherent risks of such ventures. My client never intended to defraud anyone. He intended to build an empire, to revolutionize an industry, and he believed, genuinely, that his company was on the cusp of greatness. These are not crimes. These are the casualties of ambition, the harsh realities of a cutthroat market. The investors understood the risks, and when the market turned, they sought a scapegoat. And that scapegoat is Elias Thorne. The stage was set once again for the final act of this protracted legal battle. Elias Thorne, facing the very real possibility of a lengthy sentence that could see him spend the rest of his life behind bars, watched as his fate hung precariously in the balance, a prisoner of a system he had once believed he could outsmart, now at the mercy of a deeply fractured jury and a resolute judge. Nathan Coleman, Elias Thorne's lead counsel, stood before the court, not just as a lawyer but as a storyteller, tasked with weaving a narrative compelling enough to counter the prosecution's damning accusations. His strategy was clear: reframe the entire saga, turning the victims into opportunists and Elias Thorne into a crucified visionary. "Ladies and gentlemen," Coleman began, his voice calm and reassuring, "the prosecution wants you to believe Elias Thorne is a villain. They want you to see him as a manipulative fraudster. But I ask you to look closer. Look at the context. Who are these victims of his alleged schemes? They are sophisticated investors, individuals and firms who understand the inherent volatility and astronomical risks of the tech market. They chase the promise of astronomical returns, knowing full well the dizzying heights and crushing lows that define this industry. When the market inevitably shifted, when their own speculative bets failed, they needed someone to blame, a convenient scapegoat to explain away their losses." He paused, letting his words hang in the air, allowing the seeds of doubt to sprout in the minds of the jury and perhaps even in the gallery. These are not innocent lambs led to slaughter. These are calculated players in a ruthless game, and when the game turned sour, they turned to litigation. Clara Vance, for all her claims of being a whistleblower, was an employee with a grievance, looking for a way out and a lucrative settlement. David Harrison was an investor seeking to recoup his losses through the courts after the market wiped out his investment. This isn't a story of fraud. It's a story of market forces, of a brilliant mind daring to dream big, and of those who stood to benefit from his dreams turning on him when fortunes changed. This narrative, Coleman emphasized, wasn't new. It was a consistent defense that had been in play since the notorious 2018 exposé published by Financial Insight magazine. That investigative piece, titled "The Unraveling of a Unicorn," had been the first public unraveling of Thorne's digital empire, painting a complex portrait of a visionary teetering on the edge of ethical boundaries. It chronicled Elias Thorne's meteoric rise from a garage startup to a Silicon Valley darling, lauded as a pioneer whose innovations reshaped the tech landscape. He was the quintessential self-made billionaire, charismatic, brilliant, and fiercely ambitious. He built his company, LumenEdge Technologies, on the promise of groundbreaking AI, promising to revolutionize data analytics and predictive modeling. Investors flocked, seduced by his vision and the promise of exponential growth. But the exposé also hinted at the relentless pressure to deliver, the desperate measures taken to maintain the illusion of success, and the subtle, then not so subtle manipulations of financial data to keep the investment spigot flowing. The trial, therefore, wasn't just about the facts of a specific fraud case. It was a clash of titans, a battle for the very soul of Elias Thorne's legacy. Was he the brilliant, misunderstood pioneer whose aggressive tactics were merely part of the high-stakes tech game? Or was he a calculating criminal who leveraged his charisma and technological genius to defraud investors? The defense's narrative painted him as a victim of a system that often fails to understand true innovation, a man whose ambition was mistaken for malice. As the jury retired once more, their task of deciding Lena Chen's complicity, and by extension Thorne's ultimate fate, seemed impossibly burdened by the weight of these two conflicting narratives. The courtroom drama had transcended the dry facts of the case, becoming a profound meditation on ambition, ethics, and the unforgiving nature of the corporate world. The outcome would not only shape Elias Thorne's future, but also send a powerful message about the true cost of unchecked aspiration and the often blurred lines between innovation and deceit. Considering the intense pressure and conflict within the jury if you were a juror in a high-stakes trial, what personal qualities or strategies do you think would be most important for you to maintain focus, fairness, and collegiality amidst difficult deliberations? Thank you for joining me on this journey into the heart of the courtroom drama. I wish you all good health and well-being. If you found this story thought-provoking and engaging, please consider subscribing to the channel for more deep dives into fascinating narratives and the lessons they hold.